Hey everyone, today is June 2024 and we are focusing on the EU AI Act as it stands now, looking ahead to its impact in 2026. This video will guide you through what the Act is, who it binds, and the compliance timeline, including the recent updates from the Digital Omnibus on AI. I'm Adam, a technology lawyer and legal AI expert, here to help you navigate these important developments. Please take a moment to read this important disclaimer. This material provides general information about EU legislation, specifically the EU AI Act, purely for educational purposes. It is not legal advice and does not create any lawyer-client relationship, so it should not be relied upon for making specific decisions or filings. The rules changed just yesterday, with Regulation EU 2026-1744, known as the Digital Omnibus on AI, being published on July 24, 2026, and coming into force only 3 days later on July 27th. This quick implementation was deliberate because the amendments needed to take effect before the original high-risk deadline on August 2nd, which was only 6 days away. As a result, the AI Act we refer to now isn't the original 2024 version, but the 2024 text as amended. From this change, three important points follow. First, the urgency was intentional to prevent the original deadlines from applying. Second, the deferrals in the law are now unconditional, meaning the readiness assessment that was initially needed was removed in favor of fixed calendar dates. And third, most of the Act remains unchanged. This is a targeted amendment, not a complete rewrite. The core risk-based approach, Annex 3, and the general purpose AI framework are still intact. The AI Act is fundamentally a product safety style regulation applied specifically to AI systems. It's important to note that it does not establish a general right to explanation, nor is it a data protection law. Instead, it operates alongside the GDPR, complementing rather than replacing it. Unlike a directive, this is a regulation, which means it's directly applicable in every member state without the need for national transposition. However, member states still have responsibilities like designating authorities and setting procedural rules. The Act is risk-based rather than technology-based, so obligations depend on how a system is used, not how it was built. This means the same AI model might be unregulated in one context but considered high risk in another. Duties under the Act also vary based on roles, provider, deployer, importer, or distributor, and one organization can hold multiple roles simultaneously. Finally, the Act has an extraterritorial reach, covering providers outside the EU who place AI systems on the EU market, as well as non-EU actors whose AI outputs are used within the Union. This is all established under Regulation EU 2024-1689, Articles 1 through 3. This slide is all about understanding your role under the AI Act, which is crucial because it's the very first question you need to answer when doing any analysis. The roles are clearly defined in Article 3, and getting this right is essential because different roles come with different obligations. For example, a provider, defined in Article 3(3), is the one who develops an AI system or has it developed, then places it on the market or puts it into service under their own name or trademark. This role carries the heaviest obligations. Then we have the deployer, according to Article 3(4), who uses the AI system under their own authority but not just for personal, non-professional use. Most businesses and law firms fall into this category. Next is the importer from Article 3(6), who places a system on the EU market under someone else's name or trademark, specifically when that person is established outside the Union. The distributor, outlined in Article 3(7), is anyone else in the supply chain who makes the AI system available on the EU market. Finally, pay close attention to Article 25. If you put your name on a high-risk system, significantly modify it, or change its intended purpose, you automatically become the provider, which means you take on all the related responsibilities. Understanding which role you are in is fundamental to navigating the AI Act compliance landscape effectively. Let's take a closer look at the architecture of the risk framework for AI regulation, which is organized into four distinct tiers. First, the unacceptable tier represents AI applications that are completely prohibited. These are outright banned under Article 5 with no possibility for compliance and will incur the top penalty. This rule has been in effect since February 2nd, 2025. Next, we have the high risk tier, which is heavily regulated. AI systems in this category are allowed, but only if they comply with a full conformity regime. This includes rigorous risk management, data governance, detailed documentation, human oversight, logging, and maintaining accuracy and robustness. These requirements become applicable starting December 2027 or August 2028. The limited risk tier focuses mainly on transparency duties. AI systems here are permitted but must adhere to disclosure obligations under Article 50, ensuring that users are aware they are interacting with or viewing AI generated outputs. This obligation came into force on August 2nd, 2026. Finally, the minimal risk tier covers the majority of AI used in everyday business. These systems are largely unregulated aside from a general AI literacy duty specified in Article 4 and have no fixed compliance dates. It's important to note that general purpose AI models are handled differently. They fall under Chapter 5 and are outside this four-tier system. This layered approach allows regulation to be tailored based on the level of risk involved with different AI applications. This slide covers Tier 1 prohibited practices under Article 5, which become applicable starting February 2nd, 2025. It's important to understand that these are outright bans, not obligations, and no conformity assessment can make these practices lawful. The key prohibitions include the use of subliminal, manipulative, or deceptive techniques that significantly distort behavior and cause harm. Also banned is exploiting vulnerabilities related to age, disability, or specific social or economic situations. Social scoring that results in unjustified or disproportionate detrimental treatment is prohibited as well. Predicting criminal offenses based solely on profiling or personality traits is not allowed. Additionally, the untargeted scraping of facial images from the internet or CCTV to build recognition databases is forbidden. Inferring emotions in the workplace or educational settings, unless for medical or safety reasons, is also banned. Biometric categorization to deduce protected characteristics like race, political opinion, or religion is prohibited. Lastly, real-time remote biometric identification in public spaces for law enforcement is only allowed under very narrow exceptions. Each of these prohibitions has detailed conditions and exceptions outlined in Article 5 and its recitals, so it's crucial to carefully read and understand the full provision before advising. Starting December 2nd, 2026, Article 5(1) introduces two new prohibitions under the Omnibus regulations. First, the creation or manipulation of non-consensual intimate imagery by AI systems, often marketed as nudifier tools, is explicitly banned. Second, AI systems that generate or manipulate child sexual abuse material are also prohibited, with the recitals classifying this behavior as sexual violence and abuse. Providers will be held accountable if their systems are intended for or can reasonably foresee producing such material without implementing adequate technical safeguards. Deployers are liable only when the system is actually used for these purposes. Safeguards highlighted in the recitals include refusal training, prompt guardrails, content filtering, and abuse detection. Failure to comply may result in penalties up to UR 35 million or 7% of worldwide annual turnover, whichever is higher. Existing criminal law and relevant directives remain in force during the interim period. Here in Tier 2, we're dealing with high risk AI systems, but there are actually two very different routes for how they're regulated. Article 6 sets out two independent gateways, each with its own deadline, which means it's no longer just about classifying the AI, it's about identifying which pathway applies. First, under Annex 3, we have the standalone high risk AI systems, which cover specific listed use cases like biometrics, critical infrastructure, education, employment, and law enforcement, among others. The obligations for these systems come into effect on December 2nd, 2027. Then there's Annex 1, which deals with embedded high risk AI, meaning AI integrated as a safety component in products already regulated by EU safety legislation, such as medical devices, machinery, or civil aviation equipment. For these, the obligations begin later, on August 2nd, 2028. Importantly, the Omnibus regulation narrowed the definition of safety components. It clarified that AI that merely assists or optimizes without posing a health or safety risk if it fails isn't automatically high risk. Also, Annex 3 was not amended by the Omnibus, so any system considered high risk before July 27, 2026 remains so today. This distinction is crucial for understanding compliance timelines and responsibilities going forward. Here we are looking at the Article 6 tree filter, which is a key step in determining whether a system is considered high risk under the regulation. Now, simply falling within an Annex 3 heading doesn't automatically mean a system is high risk. This filter allows a provider to decide otherwise if the system does not pose a significant risk of harm. There are four permitted grounds for this decision. The system might perform a narrow procedural task, improve the result of a previously completed human activity, detect decision-making patterns without replacing or influencing the human assessment, or perform a preparatory task to an assessment. However, profiling natural persons is always considered high risk, and this exemption never applies to it. It's important that the assessment is documented before the system is placed on the market. Plus, a national authority can demand this documentation. The Commission even proposed dropping the database registration for systems that are self-assessed as not high risk, but that proposal was rejected. Registration remains crucial for market surveillance and public accountability, though a couple of data points were trimmed. So, when you decide we decided it is not high risk, that's not the end. It's a decision that must be thoroughly documented and defensible. At Tier 2, a high risk provider needs to build robust systems engineering and governance measures, which are not just paperwork to complete at the end, but ongoing obligations outlined in Chapter 3, Section 2. First, under Article 9, there must be a continuous and iterative risk management system that covers the entire life cycle of the product. Next, Article 10 focuses on data governance, requiring training, validation, and testing datasets to be carefully examined for bias. Article 11 demands technical documentation aligned with Annex 4 content to be fully prepared before the system is deployed. Logging, according to Article 12, involves automatic recording of system events throughout its lifetime to ensure traceability. Article 13 emphasizes transparency to deployers through clear instructions for use that guarantee safe operation. Then, human oversight must be built in by design under Article 14, allowing a real person to intervene when necessary. Article 15 addresses accuracy, robustness, and cybersecurity, which need to be appropriate to the intended purpose and clearly declared. Finally, Article 17 introduces a quality management system which is now more accessible for SMEs and small mid-cap companies under a simplified regime. Beyond these, providers must also comply with conformity assessment as described in Article 43. Declare conformity under Article 47. Apply CE marking per Article 48. Register systems according to Article 49 and implement post-market monitoring and serious incident reporting as required in Articles 72 and 73. These elements together form the backbone of compliance and safety for high-risk providers. It's essential to understand these obligations as a continuous integrated process rather than a checklist. This slide covers the responsibilities of a Tier 2 deployer under Article 26, which is generally lighter than the obligations for providers but still very important. Most organizations, including law firms and businesses, fall into this category. The first key point is to use the system exactly as the provider instructs, because deviating from these instructions could make you a provider under Article 25. Next, it's crucial to assign human oversight to people who not only have the training and authority, but can also actually override the system when necessary, not just sign off on it. Controlling your input data is also essential. Make sure it is relevant and truly representative of its intended purpose. You must monitor how the system operates, and if any risks arise, suspend its use, notify the provider, and report any serious incidents under Article 73. Additionally, where you control logs, you need to keep them for an appropriate period, usually at least 6 months, unless other laws say otherwise. Finally, if a high-risk system affects someone's decisions, you must inform them and, if requested, explain how the system plays a role. Also, public bodies and certain private deployers have to complete a fundamental rights impact assessment under Article 27 after December 2nd, 2027. These steps ensure responsible deployment while protecting users and stakeholders. Starting August 2nd, 2026, a new set of obligations under Tier 3 will apply, and these affect many more organizations than the high-risk categories do. The first key requirement is interaction disclosure. People must be clearly informed when they are interacting with an AI system unless it's obvious to a reasonably well-informed person. This includes chatbots and voice assistants. Next, synthetic content marking is crucial. Providers of AI systems that generate synthetic audio, images, video, or text must mark these outputs in a machine-readable way that makes it clear they are artificially generated. Then there's deepfake disclosure. Deployers must disclose when content has been artificially created or manipulated, especially if it involves real people, objects, or events, to prevent misinformation that might seem authentic. For emotion recognition and biometric categorization, deployers need to inform users and ensure that personal data processing complies with data protection laws. Lastly, AI-generated public interest text must also be disclosed as AI-produced unless a human has reviewed it and editorial responsibility is clearly assigned. There is a grace period for systems placed on the market before August 2nd, 2026. They have until December 2nd, 2026 to comply with marking duties. After August 2nd, compliance is immediate. This framework ensures transparency and builds trust as AI becomes ever more integrated into daily life. This slide focuses on the separate regulatory regime for general-purpose AI models, as outlined in Chapter 5. These rules have been in effect since August 2nd, 2025, and were largely left unchanged by the Omnibus Amendment. Importantly, they bind the model providers directly rather than the businesses that use these models. Under Article 53, baseline duties require providers to maintain technical documentation of the model and provide information to downstream users who integrate the AI. They must also have a copyright policy that respects text and data mining exceptions, along with a sufficiently detailed public summary of the training data used. Systemic risk is addressed under Articles 51 and 55. A model is presumed to carry systemic risk if its cumulative training compute exceeds 10 to the 25th floating point operations, which refers to total compute over time, not a per second rate. When this threshold is met, additional duties come into play, including thorough model evaluation, adversarial testing, risk assessment and mitigation, serious incident tracking and reporting, and robust cybersecurity measures. Compliance is currently demonstrated through codes of practice under Article 56 until harmonized standards are established. Notably, the Omnibus Amendment skipped from Article 50 directly to Article 56, leaving Article 51 to 55 and their provisions unchanged since August 2025. Let's walk through the timeline of how the Digital Omnibus became law. It all started on November 19, 2025, when the European Commission proposed the Digital Omnibus package. Then, after several months of discussions, a political agreement was reached between the Parliament and the Council on May 7, 2026. Following this, on June 16, 2026, the European Parliament adopted the text, moving the process forward. The Council gave its final adoption on June 29th, turning the proposal into law. The Act was officially signed on July 8, 2026. Just a couple of weeks later, on July 24th, it was published in the official journal as Regulation EU 2026-1744. Finally, the regulation entered into force on July 27th, which was the third day after publication. It's important to note that there's a parallel digital omnibus related to data that would amend the GDPR, but that remains a separate file still under negotiation, so we shouldn't confuse the two. This update focuses on several important changes brought by the omnibus. First, high-risk deadlines have been deferred to give more time for compliance. For example, Annex 3 standalone systems are now due by December 2nd, 2027 instead of August 2nd, 2026, and Annex 1 embedded systems have moved from August 2nd, 2027 to August 2nd, 2028. One significant change is that the readiness trigger has been deleted. Previously, the new deadlines depended on a commission assessment confirming that standards and tools were ready, but now these dates are fixed on the calendar without conditions. Next, there are two new prohibitions added. From December 2nd, 2026, non-consensual intimate imagery and child sexual abuse material are explicitly banned under Article 5(1). The update also softens the requirements around AI literacy. Article 4 now calls for measures to support staff AI literacy but drops any specific required level, keeping the duty but removing the hard edge. Another notable addition is Article 4A, which establishes a legal basis for processing special categories of personal data to detect and correct bias, but only under strict necessity and safeguards. This applies beyond just high-risk providers and does not mandate running such tests. Small and medium-sized enterprises get relief too, with a simplified quality management regime covering SMEs and a new small mid-cap category introducing a cap on mid-tier fines. Additionally, machinery regulations are being shifted from Annex 1 Section A to Section B, meaning AI-specific safety requirements will be integrated directly within the machinery framework. Finally, the powers of the AI Office are consolidated under a new Article 75A, bringing all supervisory and enforcement powers into one place for clearer authority and coordination. Let's clarify some important points about the recent update to the AI Act that often get misunderstood. First, when you hear that the AI Act has been delayed, it's important to know this is only a partial deferral. Some rules, like prohibitions, have been in effect since February 2025, and general purpose AI regulations started in August 2025. Transparency requirements under Article 50 are still set to begin on August 2nd, 2026. The only major change concerns the high-risk chapters which have been postponed. Next, you might hear that the dates for these changes could shift again. However, the mechanism that would have allowed those shifts has been removed. Now, any new changes would need a completely new proposal and full legislative process, so you should plan on these dates being fixed. Another point is about registration for self-assessed AI systems. Contrary to some claims, this requirement was proposed and then rejected, not scrapped. The adopted version keeps this registration, viewing it as essential for market oversight and ensuring public accountability. The only adjustment was the removal of two specific data points from Annex 8, Section B. Finally, regarding Annex 3, there is no cutback. It remains as it was, meaning any system classified as high risk before the update is still high risk now, but with more time to comply. Your prior classification efforts remain valid. Here we have the compliance calendar, which puts every key date you need to know all in one place. Starting with February 2nd, 2025, when Article 5 prohibitions and the AI literacy duty under Article 4 come into force. Then, on August 2nd, 2025, the general purpose AI rules in Chapter 5, governance structures, and most penalty provisions will take effect. Moving to July 27th, 2026, we see the Digital Omnibus on AI regulation entering into force. On August 2nd, 2026, just 6 days later, there's a general application date with Article 50 transparency requirements for newly placed systems. Looking ahead, December 2nd, 2026 introduces new Article 5 prohibitions and marking duties for pre-existing generative systems. By August 2nd, 2027, Member states must operate at least one national AI regulatory sandbox, with key guidance on delegated acts and Annex 1 due. Then, December 2nd, 2027 marks when Annex 3 standalone high-risk obligations, including the Fundamental Rights Impact Assessment, become applicable. August 2nd, 2028 sees Annex 1 embedded high-risk obligations come into force. Finally, by August 2nd, 2030, all pre-existing high-risk systems used by public authorities must comply regardless unless they undergo significant design changes, a crucial transitional rule to keep in mind. Understanding these dates is critical for staying compliant and prepared as AI regulations evolve. Let's talk about enforcement and penalties under Article 99. There are three penalty tiers, each based on the higher amount between a fixed euro sum or a percentage of the company's total worldwide annual turnover from the previous financial year. These tiers remain unchanged by the omnibus. First, the most severe tier can reach up to 35 million euros or 7% of worldwide annual turnover. This applies to breaches of the Article 5 prohibitions, including two new prohibitions effective from December 2nd, 2026. Next, penalties of up to 15 million euros or 3% of annual turnover cover non-compliance with most other key obligations. This includes duties for providers and deployers of high-risk systems, transparency requirements, and obligations related to notified bodies. Lastly, the lowest tier imposes fines up to 7.5 million euros or 1% of turnover. This is for supplying incorrect, incomplete, or misleading information to notified bodies or national authorities. For SMEs, startups, and now small mid-caps, the maximum penalty is the lower of the two amounts, not the higher. Also, providers of general-purpose AI models have a distinct enforcement regime under Article 101. First, take inventory of anything that generates content. This includes chatbots on your website, drafting assistants, synthetic voice or image tools, and automated client correspondence. Article 50 applies to all of these. Next, check the disclosure layer. Make sure that any user interacting with your AI knows they are doing so. It needs to be clear and obvious to a reasonably well-informed person, not just assumed. Then separate old systems from new ones. Any system placed on the market from August 2nd, 2026 must immediately meet the marking duty, while existing systems have until December 2nd, 2026. After that, fix your role in writing, whether you are a provider or a deployer for each system, and verify against Article 25 that rebranding or modifications haven't shifted your responsibilities. Also, document your Article 6.3 decisions now, especially if you've concluded that certain systems are not high risk. This documentation should exist well before December 2027. Finally, don't stand down your high risk work. Although 16 months might seem like a long lead time, delays from notified body queues, evidence backlogs, and budget cycles can quickly eat into that time. Staying proactive is key. To wrap up, there are three key takeaways to remember. First, the architecture survived the amendment. Risk tiers, role-based duties, Annex 3, and the general-purpose AI regime remain intact. So, if you understood the AI Act back in June, you still understand it today. Only the timeline has shifted, not the framework. Second, the nearest important date is actually being overlooked. While most focus on December 2027, the real deadline to watch is in just 6 days. Article 50 Transparency, which applies to far more organizations than the high risk provisions ever will. And finally, deferred does not mean cancelled. The removal of the readiness trigger makes these upcoming deadlines tougher to postpone, flipping the risk dynamic. It used to be about building early, but now waiting carries the risk. On this final slide, I want to emphasize that all the key points we've discussed are grounded in primary sources. Every significant statement in this presentation directly references the official EU regulations such as Regulation 2024-1689 and Regulation 2026-1744, which cover the Artificial Intelligence Act and the Digital Omnibus on AI respectively. These documents include detailed annexes that define high-risk AI systems, technical documentation requirements, and registration data fields. Additionally, guidelines and codes of practice issued by the European Commission's AI Office, along with national competent authorities' roles in designations and sandbox arrangements, form an essential part of the regulatory framework. Finally, please remember this presentation provides general information and not legal advice. For specific guidance, always consult a qualified lawyer familiar with the laws of the relevant member state.